Hello, my name is Brian Cronin. Welcome to this tutorial on the legal opinion EQE paper D2. This is part 1 of the tutorial, Assimilating and Organizing Information. The tutorial is presented in 3 parts. Part 1, as I said, is Assimilating and Organizing Information, which is this part. Part 2, Legal Consequences and Planning. And part 3, the legal opinion and comments. And I recommend that you follow the tutorial in this sequence. We'll begin with a few words about the current structure of the EQE paper D. Part 1, or D1, consists of so-called short questions. There are about 5 questions in all, and the available marks for each question are indicated. D1 accounts for about 40% or 40 marks out of the total of 100. Part 2, or D2, consists of one long letter from a client that sets out a complex legal situation, including several questions you are asked to answer. D2 accounts for about 60% of the marks, or 60 marks, and the marks for the individual D2 questions are not indicated, so you just have to reply to D2 as a whole. You have in all 5 hours to answer the D1 and D2 questions. How you allocate the time is left up to you. Now some notes on tackling D1 and D2. In this tutorial, we are going to concentrate on D2, which is the legal opinion. We will not cover in detail your preparation for D1, but here are some comments about D1 and D2. For your D1 answers, you must, I repeat, must quote the legal basis of the answer. For your D2 answers, you are not expected to quote the legal basis. You can develop a good answering style compatible with both D1 and D2 in the following way: by paraphrasing the legal basis in your answer associated with identifying the legal basis, for example, quoting the article or rule in parentheses for your D1 answers, and paraphrasing the legal basis in your D2 answers along with the legal consequence, but without quoting the legal basis. So you can use a similar approach for the D1 and the D2 answers. And you can and you should use the European Patent Convention, the PCT, and the guidelines to paraphrase the legal basis, so you should have those materials available to you when you are writing. Next is a comparison of the working methods for paper B, paper C, and paper D2. Here I've set out the paper, what you have to assimilate in the paper working towards the end product, the planning that you have to do with the legal consequences for that paper, and the end product that is delivered from your notes. For the reply, which is paper B, you have to assimilate the facts from your client's proposal, the client's proposed claims, and the client's application already filed, and the prior art which is given to you in the question. You have to assimilate all those facts in view of the end product, which is the amended claims and structured letter. For the B paper, your planning and legal consequences is going to be determined by the structure of the reply letter to the EPO that you're going to generate. So the reply letter will start normally with things like basis of amendments, novelty, inventive step in the problem and solution approach. and that will provide a particular structure for your answer, and you'll use that structure for your answer to organize or to assimilate the facts from the beginning and to carry out your planning. In the opposition paper, which is paper C, the materials you have to assimilate are the opposed claims, the opposed patent, and the documents provided by the client for attacking the opposed patent. Your end product is going to consist of more or less only a statement of opposition, organized claim by claim, claim ground document structure. And that organization of your end product is going to determine how you assimilate the materials to begin with, and how you do your planning, which is going to be determined by the grounds of attack and by the claim structure. So there is a definite way that you should organize your opposition paper C to get to a good result. For the legal opinion paper D2, it's a little bit more difficult. The end product is going to be a structured legal opinion that answers the client's questions, and to get there you have to intake the information from the client's letter that is needed to answer those questions. So we will start by looking at the questions. We will organize the information from the client as a function of the questions, and the planning will consist of, or will be determined by, the legal consequences that emerge from the situation. And we'll do this as we go along. For the legal paper, we will work out how we're going to process the paper. So first a word then about legal consequences. There is a big difference between paper B or paper C on the one hand and the legal opinion paper D2 on the other hand. This difference is that papers B and C have fixed legal consequences, and you process these papers aiming to reach the predetermined legal consequences. To give an example, the legal consequences for paper B will be patentability, it will be novelty, an inventive step, and so on. And the legal consequences for paper C will be absence of patentability, and it will be, for example, lack of novelty and lack of inventive step. And those are the legal consequences you will aim for and you will use to process the paper. The D2 paper, on the other hand, does not have any fixed legal consequences that are predetermined, as you have for paper B and C. The legal consequences for paper D2 depend on the situation and are a function of the client's questions. It follows that for D2, the legal consequences emerge as you proceed. Also, you must focus on the client's questions in order to identify the relevant legal provisions, and I said dégager in French, to extricate in English the relevant legal consequences. So next then is an outline of how to process the complex legal situation. To begin with, you can go quickly to the client's questions that are dispersed in the letter or at the end. You may want to make a first preliminary scan, but as soon as you've done that, go straight to the client's questions, normally at the end of the client's letter. Then you need to work out what you need in order to answer each of the client's questions. So the client's questions usually consist of a status report where you have to provide the status of a patent estate, and then it consists of some improvement, what the client has to do to improve his position. You have to find out what you have to do for each question. You can make note sheets or use sheets of an exercise book, or you could even use sheets of the exam paper that you are given in the exam that you can use to make your notes on. On each note sheet, you should write a header corresponding to a question raised by the client or a segment of a question, leaving a blank space to enter information. Then, in a first scan of the client's letter, you need to highlight all dates and get familiar with the timing. And you need, possibly at this stage or later if you wish, to make a display of the dates for each situation. And you can do this, as I say, early on and complete it later, or you can do it all later on. Continued over. Next, make a purposeful reading of the client's letter. As you go along, highlight the facts relevant to the client's questions and note the facts on your relevant note sheets pertaining to that question. So you gradually group together the facts pertaining to each question raised by the client. You have to pay particular attention to dates. Dates are relevant facts that trigger legal consequences, and we'll continue over. Then you can make a second purposeful reading of the client's letter. As you go along, concentrate on the facts that lead to legal consequences relevant to the client's questions. Work out the legal consequences on your note sheets and use a date diagram to work out the date-related legal consequences. We will make this second reading in part 2 of the tutorial, Organization and Planning. Continued over. You should then organize the notes on your note sheets into the format of an answer to the client's questions, and at the same time rehearse the answer you're going to write. Again, we will do this in part 2 of the tutorial, Organization and Planning. And lastly, you need to write a structured answer to the client's questions from your notes in the form of a legal opinion that contains facts, paraphrased legal provisions, legal consequences, and advice. And we will do this in part 3 of the tutorial, the end product. In your preliminary scans, it's a good idea to familiarize yourself with the parties involved. So here's the who's who. Typograph X is an Italian company specializing in printing machines, and Typograph X is your client who explains the situation and requests you to reply to their questions. Druck Z is a cooperating or competing German company. We'll see they have stolen the invention of the client and filed it. Print L is a Chinese competitor who we'll see has a competing patent application. And ICPR G is a competitor from Iceland who also has a competing patent application. You need to identify the parties for your comfort level and in order to avoid getting confused as you read the client's letter. Now we turn to the client's questions. These are at the end of the letter. Question 1. What is the current situation concerning the following printing machines? M plus A, M plus A plus B, M plus A plus C, M plus A plus B plus C, and M plus A plus B plus C plus D. Current situation means the present patent situation for which you have to make an up-to-date status report, and you have to do this for each printing machine type, M plus A, M plus A plus B, M plus A plus C, M plus A plus B plus C, and M plus A plus B plus C plus D. You can set up separate note sheets for each machine type where you will gradually list and gather all relevant facts to the current status of related patent applications and patents. And for example, you may want to look for the following types of information. Is there a patent application? Has it been filed? Who is the owner? Is priority claimed? Is the patent application novel? Is it inventive? Is there an inventive step? What is the legal status of the patent application? Have the fees been paid, etc.? Has it been withdrawn? And what is the scope of the protection, and so on. So you're going to have to look for all of those facts in relation to each machine type as you read the client's letter. Next, we'll have a glance at question 2. Question 2, which we now have on the slide. As the situation currently stands, are we, that is typograph X, free to produce, sell, and use our printing machine M plus A plus B plus C plus D? So this question is about freedom to operate, and the freedom to operate for that particular machine can be obstructed by an earlier competitive patent or patent application, perhaps, of the same scope or broader scope, which is legally valid and which covers territories where the client produces, sells, or uses the machine M plus A plus B plus C plus D, or intends to do this. Question 2 implies, in fact, that question 1 involves working out the current scope of the competitors' patent applications. You can set up a note sheet for gathering relevant information on question 2, and you can do this after having worked out the current situation for question 1. Now we'll look at question 3. Question 3 is, what can we do to improve our rights and our position, that is, typograph X, our position vis-a-vis ICPR G and print L with respect to the various printing machines mentioned above? So for this question, we've got to find out what are the rights, patent rights, held by ICPR G and print L. We have to improving our rights means taking any actions to perfect our patents or patent applications, including such things as refiling under priority, PACE, PCT, national phase, EP grant nationalization, filing divisionals, or anything that you can do to improve your position. And improving our position vis-a-vis competitors also includes things like filing third-party observations and filing opposition and so on. I would suggest that you set up a note sheet for gathering the relevant information for question 3 after having worked out questions 1 and question 2. And I, in my own wisdom, have made out several separate note sheets for improving each machine type, M plus A, M plus A plus B, M plus A plus C, M plus A plus B plus C, and M plus A plus B plus C plus D. Although it's not strictly speaking necessary to do that, I thought that that was a good way of being sure that I would get to a complete answer. Let's now begin with some preliminary notes on the current situation of M plus A that we will have noted down as we go along. These then are preliminary notes I gradually gathered as I read the situation the first time. and I read, feature A allows machine M to increase its speed. EPX1 covers M plus A, filed July 2012 by typograph. EPX1 search report cites EPZ. EPZ first filing for M plus A 2012 by Druck Z. EPZ withdrawn November 2013. Court decision on 15 January 2015. The old machine M is prior art against EPZ. EPG describes and claims M plus A and M plus A plus B, and EPG is filed May 2012 by ECPRG. These are the facts relating to the machine M plus A. We can organize or reorganize these facts later. Next, or in practice at the same time, we can make a first date diagram. In practice, I've done a single date diagram for each situation, but in practice, you may want to make a big date diagram on an A3 sheet covering all machine types so that you have everything available on one sheet. For the purpose of the tutorial, I've done separate date diagrams for each machine type. So we will begin by having a look at a preliminary date diagram for M plus A. Here now are the facts that we saw before, but arranged in date order. Time is flowing up, so the future is at the top of the sheet. And in time order, reading from the beginning, we have the old printing machine. We have confidential disclosure of M plus A to Druck Z in February 2002. EPZ was filed covering M plus A in March 2012. EPG was filed covering M plus A and M plus A plus B in May 2012. And EPX1, which is our client's application for M plus A, was filed in July 2012. So that puts the different applications into their time perspective. Looking into the future, in October 2013, there is a search report for EPX1 citing EPZ. In November 2013, EPZ is withdrawn. In January of 2015, 15th of January, there is a final decision from the German court entitling typograph X to the grant of a EP patent for M plus A. And today is the 24th of February 2015. So that is the first date diagram without making any extrapolations and without drawing any legal consequences at this stage. We'll do that and complete the date diagram later in part 2 of the tutorial. Next, we turn to M plus A plus B. Here are the preliminary notes on the current situation. Feature B enables to use various types of paper. EPX2 was filed 10th of March 2014 and includes a claim to M plus AB, also to M plus A plus C plus and A plus M plus A plus B plus C. EPX3 was filed 20th of January 2015 and it includes a description of M plus A plus B and others and claims to M plus A plus B plus C plus D. And ICPRG was filed as EPG in May 2012 and includes a claim to M plus A plus B, and it also includes M plus A. So they are the facts that as they emerge. Let's now consider a first or a preliminary date diagram for M plus A plus B to try and get the facts into date perspective. Here then are the facts for M plus A plus B in date order. I left out EPX1 and EPZ. If you do a bigger date diagram, you can of course include these. The relevant timing from bottom to top, from the past to the future, is therefore EPG is filed in May 2012 and covers M plus A and M plus A plus B. EPX2 is filed 10th of March 2014 and covers M plus A plus B, M plus A plus C, and M plus A plus B plus C. EPX3 is filed 20th January 2015 and it includes M plus A plus B in the description and a disclaim to M plus A plus B plus C, D. There again, this is just entering the bare facts without, at this stage, making extrapolations or without drawing legal consequences that we'll do in part 2 of the tutorial. So this time diagram is just a framework for later making the extrapolations. Next, we have some preliminary notes on the current situation of M plus A plus C. Starting with feature C reduces the number of misprints of M plus A, which is an effect of the feature. EPX2 is filed 10th of March 2014. EPX2 includes claims to M plus A plus C, also M plus A plus B and M plus A plus B plus C. Print L is displayed at an MAC prototype on 10th of February 2015. I think we jumped over that one. PCTL was filed 8th of September 2012 by Print L. PCTL had a positive International Preliminary Examination Report. It was published 13th March 2014 and it describes and claims M plus A plus C. All that is not in time perspective yet. We need to set up a date diagram. So here we have the first date diagram for the current situation of M plus A plus C. In date order, we have the old printing machine as the prior art. PCTL was filed the 8th of September 2012 for M plus A plus C. It's the first filing. EPX2 is filed 10th of March 2014 and it covers M plus A plus C, M plus A plus B, M plus A plus B plus C. PCTL was published on the 13th of March 2014. EPX3 was filed the 20th of January 2015 and it describes M plus A plus C. 10th to 12th of February 2015, Print L displays a prototype of M plus A plus C, and today is the 24th of February 2015. There again, that's the sheer initial date diagram without extrapolations. For the extrapolations and legal consequences, they will come later in part 2 of the tutorial. Next is M plus A plus B plus C. Here are the facts for M plus A plus B plus C. Feature C reduces misprints. Features B plus C in M plus A plus B plus C significantly reduce noise. EPX2 is filed on the 10th of March 2014 and it claims M plus A plus B plus C and M plus A plus B and M plus A plus C. And EPX3 was filed on the 20th of January 2015 and it describes M plus A plus B plus C, and it claims M plus A plus B plus C plus D. Here then is a preliminary date diagram which puts that into time perspective. I left out the prior art at the beginning because it has to be worked out, and we'll do that later. 10th of March 2014, EPX2 is filed, covering M plus A plus B plus C, amongst others. 20th of January 2015, EPX3 was filed, covering M plus A plus B plus C, amongst others, and claiming the D version. And today is the 24th of February, so there's not a whole lot of information on that timesheet. But it provides a good framework for adding extrapolations like the prior art and legal consequences later. Now we turn to the facts for M plus A plus B plus C plus D. Here, the new feature D is hidden in the machine and reduces the consumption of ink. EPX3 was filed on 20th of January 2015 for M plus A plus B plus C plus D. There was a paragraph missing with a sufficient description of feature D. 10 to 12 February 2015, a prototype of M plus A plus B plus C plus D was demonstrated. And the client Typograph X is ready to start producing M plus A plus B plus C plus D in the summer of 2015, and they made no disclosure about feature D to anybody. So here then are the basic facts, and now we come to the basic date diagram. Here are the dates in date perspective. 20th of January 2015, EPX3 is a first filing of M plus A plus B plus C plus D, and it's the only filing, and it files the claim only, and there is no sufficient description for D. 10th to 12th of February 2015, the demonstrated prototype of machine A plus B plus C plus D was publicly demonstrated, but feature D was hidden. We come to today, and we're projecting into the future. In summer of 2015, the client is ready to start producing. But there again, we have not made any extrapolations. Here are a few notes on the date scan for the current situation and future developments. The idea of making a preliminary date scan is to set up one or more preliminary date diagrams indicating the events in their time relationship. We've seen that as it happens. In part 2, for future developments then, we will initially concentrate on developing the current situation so that we can reply to question 1, and we will complete the preliminary date diagrams by extrapolating legal time periods into the future, and we will use the diagrams to visualize legal consequences on issues like novelty and possibly inventive step and so on. And we will also use the diagrams to work out advice in reply to the client's questions. More notes on the next steps. This completes our preliminary note sheets on the current situation. The information has been organized in preparation for answering the client's questions. The next steps in part 2 are the following: to develop the legal consequences pertaining to the current situation, to set up note sheets for questions 2 and 3, to develop legal consequences for questions 2 and 3, and to develop advice in reply to the client's questions, and to consolidate our notes in preparation for writing the legal opinion. Now some closing words for part 1 of the tutorial. This is the end of part 1 of our tutorial on paper D2. Please continue with part 2, legal consequences and planning. À bientôt.